It's only from April to September. So that was the best bargain you can check out. Because the last one I remember I read up to a year, we put it in a year. I don't know. Yeah, because we put it over because we can make sure I'm like. So the first time I had, I got set up, like, I can't be. Because then you're. Third. I feel like.
All right, everyone, I'm going to call the docket. When I call the docket, let me know you are here. Stand when your name is called. Jose Angel Torres. Jose Angel Torres. Jamaria Simmons. Jamaria Simmons. Gerard Hernandez Henry. Thank you. Jesus Eduardo Garza. Jesus Eduardo Garza. Romanique Quarles. Romanique Quarles. In custody is Salinas. Andrew Arnett. Andrew Arnett. Thank you. Tyler Ashbaugh. Thank you. And nobody's to sit on the front row. Adam Gonzalez, custody. Keith Hunt. Keith Hunt. Alexandria Alvarez. Juan Arambula. In custody, we have Greg Wright, Fabian Ramirez, Richard Murray, Richard Flores Murray, Christian Smith, Kevin Carell, Joseph Grosso, Paul Bell, Larry Holmes, custody, Michael Pettis, Omar Alvera, custody, Eric Kelly. Thank you. In custody is Blas Hernandez, Joshua Kilgore, Willie Cunningham. Thank you. Terrell Guidry. Terrell Guidry. Alexandria Alvarez, you're on the docket twice. Thank you. Timothy Johnson. Timothy Johnson. Kevin Carell.
Here.
Thank you. Oscar Olvera, custody. Daniel Ramirez. Daniel Ramirez. Derek Reyes.
President, Your Honor.
Thank you. Marcelino Padilla, custody. Ray De La Rosa. Todd Dotson, that's TDC. Amaya Lewis, custody. Anyone who came in late or your name was not called. What's your name?
Rules.
All right, have a seat. Yes. I'm sorry, you said Jose Torres? Anyone else came in late or your name was not called? All right, everyone, these are the rules of the court. I repeat them every day. The reason why I repeat them every day is because people know the rules but don't follow them. To my left, court reporter, don't touch her things. Don't put your items on her desk. If you break something over there, you will have bought it. It costs $10,000. To the back, probation officer, do not crowd around her desk. Do not stand around her desk. Do not put your items on her desk. That's her desk. That's her office. If you have a client who's on probation, I would suggest you confer with the state and the probation officer. If you have a client who's in custody, yes, they need to be brought out. And the only person who can give you a reset or continuance is myself. So don't go to the coordinator asking for a continuance or a reset. I'm the only person who can do that. To the left are the boxes for criminal trial division. To the right are the boxes for family violence. Once you have conferred with your client and conferred with the state and you're ready to approach, just approach the clerk or the coordinator and ask them to pull your file. You'll be called in the order of appearance. The only exception to that is if your client needs an interpreter. Your client will need an interpreter if they do not wish to confer with or speak to the court in English. So if your client is not speaking in English, you're going to have an interpreter called. We are recessing at 12. Do not rush the court at 11:45 and thinking stuff is going to happen, because it is not. You need to have all your paperwork turned in by 11:30. We're recessing at 12. I know everybody is great to see each other. Sometimes being in court is like being at a funeral. When you're trying to take the body to the cemetery, everybody at the church wants to treat it as a reunion. So after you all handle your business, then we can have a reunion. So everyone, today is Monday. It's April Fool's Day. But hey, this is the 187th District Court, so there's no April Fools here. So everyone, confer with joy in your heart. It's a new beginning. It's Monday. Everyone, please confer.
Did Michael Feta send you the docket? I would want to Yes, perfect. Thank you.
No, it's just. What do you know? Yeah, you do. That's my doctor.
Yes.
We go.
Okay, give me just a second. I. What are we here for? Oh, I know, but.
Be on bottom line. I think that was every file, those are the case numbers that those were surveys on. I'm just trying to see if they practice so that you can just.
See my,
Is it currently on tax or?
Yeah. It's what's it. Oh, yeah.
They want to send us. We can read it. Say that.
Violation of bond ordinance.
You know, I'm gonna. I got the two sexual felonies on the side.
I'll have a check.
We may not have. Here's what I'm trying to say. So I'm on the two state jail felonies.
Yes.
He's got a 1-4.
Only one
John
I-
Robertson. We reached out for today just to give him the 2. Now he's- Well, yeah, like.
You give me just a few minutes.
Yeah, no.
I was gonna-
Oh, so it's a- take the 6.
Let's go look at it.
Actually, is it partial? It's not. I mean, I figured a partial, but I'm gonna just try. You have 6 felonies. It's partial. Partially it means like you're.
No, I know that's not gonna do.
Yeah, you can get a deep or potential life sentence. You can get a deep.
All right, why do I have this file, Greg Wright?
You ready to approach it? It's not out there.
Okay.
Yeah, you're very welcome.
Oh, yeah. I think what it-
Yeah, I have 753, and that's on, we're asking for a bond. We get partial.
Maybe yours.
No, I think they're.
So you can.
What?
What are you gonna permit, are you not?
I'm here for. Fill up, so.
No, no. If, are you, if you guys are the attorney on the.
Stranger danger.
Yeah. I think you're.
Yeah, no, you're not listed yet. If you want to go back and get. Your. Oh, you're only this, your Don Garcia, you're only this.
Oh,
You only listed on 3, the other 2.
one of the other two.
The 740. 624. 740.
I don't know.
So what's going on here with the. If you're looking back, you can fill that out, so. they
Let me get
can-
it. But, can I get the key page on this, the state for you?
Well, when you come back, I'll give you that.
Thank you very much.
You want.
I know y'all are doing some works back there now. Can I get a second in the deck? One 24 CR 0254.
Wow. Oh.
So the wonderful is.
Is Adrian okay? Sure.
So my best.
Yeah. Ready for them to finish up. I just need pictures. Are they here? Oh. I know. The recommended.
They don't pay you for taking the pain. You only get paid.
Oh, yeah, you're right.
So she's got. Yeah.
No. Yeah, see, he's already. No, it's, we're just waiting. We do. We have a ten. Yeah.
Jesus Garza.
Yes, God.
Hi. Where are we on the federal issue?
I was hoping he might be back by this time, but I guess he's still serving that sentence.
Well,
Jason
has he been-
He might have more better information in their notes. Jesus Gar's a federal guy.
Sorry, Judge,
All right. Well, has he been requested?
I have not discussed anything with this.
All right. If you want to speak to her about it. Okay.
I
Thank
mean,
you.
it's always best to do the same thing. Just wait for him.
I'm waiting for this person.
Thank you.
The DPPs are ready.
653, 623, and 653, 624.
Yeah, I don't know what time. I mean. But I just told me, I think she got here. And. I don't know.
So I tried to get a.
Oh. Well, you should have given it back. But I don't know why.
I don't know. Her mom. She doesn't.
So last year.
Well, all right. So what is happening?
And Judge, it looks like from my last note in there, that this individual should have been sentenced last Tuesday.
Okay.
Because he was continued from February to March 26th.
Okay.
So I guess just as long as how long it takes for him to get here, but they're aware on that side that he's supposed to be coming back this way.
All right. All right. So. And when was he sentenced?
He's supposed to have been sentenced March 26th.
Okay, March 26th.
How long it takes to get him here,
Yeah,
I have no
I
idea.
I don't know that answer.
All right, let's recall this for April 29th.
Okay, Judge.
Thank you, Judge.
Thank
You're
you.
welcome.
May I be excused?
Yes.
It's on the.
Okay.
They've been discussing the cases on data trail.
Yeah, no, I hadn't heard. That'd be great. I think it's the road. The end of the world. Which one?
Greg Wright. Good morning. Where's Mr. Wright?
He's in custody, Judge.
All right, has he been asked to be brought out?
No, he hasn't, Judge. He's also with Judge Carruthers this morning. That's what I wanted to let the court know.
Okay,
So he's got an agreed incompetency hearing at 10:35 this morning.
okay. Then, let me see, this is an arson, so he's gonna end up going to the state hospital, most likely.
Yes, Judge.
All right, we'll put this on. Norma, set this for June 24th. All right, thank you.
Perfect, Judge. May I be excused?
Yes.
Thank you.
All right, Ray Della Rosa. Yes, sure.
Ray?
All right, do y'all have a motion?
Yes, we have presented a motion from the fourth.
All right, can you all have, can somebody find out where this motion is? All right, thank you. I just have a seat. Once I have the motion, we'll take it up from there.
Thank you.
Thank you.
Good morning. Good morning.
All right, we're going to go on the record. Court is calling night mag number 753624. All right, do you have the motion for off the record? Do you have the motion for 2-3?
For the 2-3.
753623? Because both of these are 2-4.
No, that must be a mistype, Your Honor. I apologize. I'll get that motion to you as well.
All right.
Yeah, and it was on the 2-3. I'll make sure that's electronically filed today.
All right, so we're back on the record. Can I have parties announced for the record for the state?
Is that done for the state, Your Honor?
Defense?
Attorney John Garcia for defendant, Your Honor.
And are you Ray Della Rosa?
Yes.
All right, we're here on a motion to modify terms of bond release. State, have you had a chance to review the defense's motion?
I did, Your Honor.
All right. And defense, what are you requesting?
Your Honor, we're asking if it could be, he's under full house arrest. We're asking if he can be put on partial for employment purposes. He's a contractor. He's followed all of the rules that he was given when he was accepted into the bond program. We're asking if you could do that for him. He's been out of work for about a month now.
All right, Mr.
Thanks.
De La Rosa, can you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Ray De La Rosa.
All right, so what is your employment status?
I'm a contractor. I do house painting, carpentry, landscaping,
And what are your hours?
from 7:30 to 7 o'clock.
And what are the days you work?
Monday to Saturday.
All right, see, whenever I look for a contractor, they're like, we're not working on Saturday.
I work on Saturdays.
All right, any other questions?
No questions from the state. Your Honor.
Nothing further from defendant, Your Honor.
All right, state, are you in agreement?
Yes, Your Honor. They had initially requested just, if anything, tracking only, but the state would just respectfully request that, or in discussions with council, as opposed to full, just partial for work purposes.
All right, and what times? Do y'all want it?
30 to 70.
7:30 to 7, Your Honor. He does early contracting and stuff, so he does wake up quite early.
Yes.
All right, then the court will follow your agreement to partial GPS for employment Monday through Saturday from 7 a.m. to 7:30 p.m. And those extra 30 minutes are for you to get from place to place. If an issue occurs and you're unable to make that because you're on the job site, you need to let pretrial services know. And when you're leaving to go to the job site, you need to call pretrial services and let them know. And if they don't answer and it's a recording, you need to leave a message. You understand? All right, is there anything else?
Nothing further from defendant, Your Honor.
And nothing from the state, Your Honor.
All right, any objections to me writing on the order that this is for 753624 and 753623?
No objections from the state, Your Honor.
No objection from defendants, Your Honor.
All right. If there is nothing else, then you're excused.
Thank you, Judge.
Thank you very much, Your Honor.
You're welcome.
Your Honor, may I have a discussion?
Are you ready?
Yes.
You need to have the clerk or the coordinator pull your file. All right, thank you.
Yeah. It's going up.
Hello? Okay, all right.
No, absolutely.
Okay. ASAP. All right, thanks. Bye-bye.
So now.
Yeah.
Yeah. Check your calendar and we'll figure out. We'll bring him up in this. Yeah. Yes. I will call him.
I don't know, can I get the file?
Yeah.
He's in the hospital.
That could go over there, yeah.
All right, Marcelano Padilla.
Yeah. Hi, Judge.
Morning, Judge.
Good morning.
We're set to plea him today,
Mhm.
but evidently he is in the hospital. We don't know why, and it was not brought over, so.
All right. So did we have any idea? All right, then we will come back. We'll come back on Thursday and see where we are.
Yes, Judge.
Okay,
All right, thank you. April 4th. Hi.
Thanks, Martinez.
He is here. He was absent. Okay, just let me know. I know the names. Read all of it. Just what matters. Just like first 5 lines. No, leave it as the bit, because it puts more in the context. But I can understand what's going on. Yeah, it's, I thought you were the restrictions for what, and I is accepted maximum. Yeah. Also, before. She has, I can tell.
Yes.
Can I get your signature?
Is it from this court?
It is not, Judge, but I.
Why do people come here?
By the other court, they always do. You're always.
But I
you're
mean-
always on the bench.
But where is the judge for this?
You know, in the basement. Or no, he's on the second floor.
Okay, who's the judge?
Oh, it's no chill product.
Okay, here you go. Thank you.
Thank you. Judge.
All right, who is here on Luz Briseño? And where is Briseño? Are you all ready to proceed? Have you conferred with the state?
I have not, I was online.
All right, so once you confer with them, let me know when you're ready.
All right, thank you, Jim.
You're welcome.
And if it's possible, they have no lettuce up on the stand.
And also. So.
Yeah. We never received.
Yeah, but it's.
I know, but we don't. Like, that's the thing.
Over there. This one would work out like the batter. And after the one by all.
So it's, okay,
Never.
okay, and I never received any of them. The question becomes, say what happened with the contract. And then is he gonna withdraw the plea or not?
Wait, we're asking someone with some fun.
Okay, well then, I will take one.
That's kind of, you know. All right, we're ready. Yeah, okay, cool. Did you?
Michael Pettis?
Oh, yes, I forget, sorry.
I also thought this.
All right. So on this case, State, did you tender an offer?
Judge, we did tender an offer. I do think the bench wanted a bit of time just to go over discovery, just to make sure that we've given over everything, or that there was nothing outstanding.
All right. How old are you, sir?
45.
All right. Ms. Ferguson, recall this back in 3 weeks for a plea deadline date.
Yes,
All right, that's your plea deadline date.
Your Honor, if I may, I did want to advise the court, we will probably be filing a motion for an expert and we will file it before the next setting. But we still have quite a bit to parse through before we make a counter.
All right. That would be your plea deadline date.
I understand.
All right, thank you.
Thank you.
Good seeing you.
If you can hang outside and I will sign, I will bring you your reset form. Okay.
Jose Torres. All right, court is calling 2022 CR 11241, State of Texas versus Jose Torres. Can I have parties announced for the record for the state
Allie Jackson.
defense?
Adam Flores for the defendant, Your Honor.
Are you Mr. Torres?
Yes, Your Honor.
All right. I have on the docket that you all had a competency trial. Did you complete that?
Yes, Your Honor. And the court found him competent, Your Honor.
All right. So then the next thing we have is we're here for sentencing. According to the plea bargain agreement that was entered on April 3rd, 2023, the defendant pled no contest to count 2, count 3, and applied for deferred adjudication. The state was silent on your application. Are you all ready to proceed with sentencing?
Your Honor, and please the court, Your Honor, I was not the original attorney that was assigned to the case, Your Honor. And we discovered new evidence, Your Honor, and I asked the state for discovery. And she says she has not received it yet.
What new evidence?
Well, allegedly, there's some body worn camera from when the arrest was made. It's an at-large case, so it was like a separate thing. I requested body worn camera from the number that I was given by Mr. Flores, and I never received anything back from it.
All right. So is there body camera footage?
Not that I know of, Judge, but there could be. The only way I heard about this is him saying that his client saw body worn cameras when they came in.
All right. So the court is going to go forward with this sentencing. This has been going on since April 3rd, 2023. All right. Have both parties received the PSI report, state?
Yes, Your Honor.
Your Honor.
Defense? Anything you wish, any corrections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I read the PSI and the victims are asking for probation, Your Honor. She will not object to a probation, Your Honor. We're asking for probation, Your Honor.
All right. Anything else you want to say on behalf of your client?
No, Your Honor.
All right, the court is going to deny the application. The court will find you guilty in counts 2 and count 3. Is there anything you wish to say, Mr. Torres?
Your Honor, if you could give me a second chance, I'm so sorry if anything.
I'm sorry.
I'm
You
so,
want to raise your right hand?
I'm sorry.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jose Torres.
All right, there's something you wish to say?
Yes, Your Honor, I just wish you give me a second chance. I was, everything was good. I was working 12-hour shifts at Toyota and everything just fell apart. Just wish you give me a second chance, Your Honor.
All right, court is going to find you guilty in counts 2 and count 3. Is there any questions from either attorney?
No, Your Honor.
No, Your Honor.
All right, the court will follow your agreement. Court is going to sentence you to 4 years TDC in count 2 and 4 years to TDC in count 3. Counts 2 and count 3 will run concurrently. There should be Chapter 62 compliance and no contact with the complainants. And there'll be credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, good luck to you.
Thank you. I made this.
Yes.
Thank you.
Are you, I'll take that up in just a moment. Wilfredo Salinas? You on this side, counsel. All right, so today is the plea deadline date. Is he accepting the plea or requesting a jury trial?
No, Your Honor. Just confer with the ADA, and the ADA is requesting an opportunity to bring in the other witnesses and question them about what they know about the incident. Right now, as it stands, looking at the elements of the offense.
Well, I'm not want to get into the elements. So my question is, do y'all want a jury trial? What's happening here? Because the day is supposed to be the plea deadline date.
Again, Judge State's made another offer. We've given it to defense counsel. Defense is asking that we reach out to some of the witnesses, which I told them I'd be more than willing to do. At this point, just one short setting, and then we should be able to have a better answer.
All right, the court is recalling this for April 11th. That will be your final plea deadline date. There will be no further extensions of plea deadline dates.
Thank you.
Okay.
All right, is there anything else?
So, yeah, maybe we be excused, Your Honor?
Yes. Thanks, good seeing you. Have a good one. All right, Norman, this is April 11th. Okay. Are the parties ready on Luz Briceño? Hey. Where is Briceño? All right. Court is calling NYMAG number 751772, State of Texas versus Luz Eduardo Briceño. Could I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Joseph Holster.
Are you Mr. Briceño?
Yes, Your Honor. Yes, Your Honor.
All right, we're here on a motion to modify conditions of bond to remove the GPS device. State, have you had a chance to review the
We
document?
have reviewed, yes, Your Honor.
Do you have objections?
We do, Your Honor. We are not in agreement with that, but I believe defense has a modification of their motion to, which they'd like to take with the court.
Yes.
State, yes.
So, Your Honor, Mr. Briceño works in construction. So the device is burdensome to him and we are asking that it be removed, but alternatively, what we would ask is the court's assistance in dealing with the pretrial officer. Mr. Briceño is on partial house arrest right now. I literally thought he was on full house arrest. The pretrial officer has been so aggressive that Mr. Briceño lost a job he had just started when he contracted with me because of contact between that employer and the pretrial officer. The pretrial officer, I've spoken to him twice. He's one of the rudest people I've ever dealt with from the county. He threatened to violate my client when our consultation ran a few minutes late. He would not give us more than an hour to meet. He called in the middle of our consultation to verify that my client was physically present, despite the fact that he can tell my client's physically present because of the GPS monitor. It is incredibly burdensome to my client. So if you could just leave him monitored and remove the partial, that would solve our problem. But I don't know what's going on with pretrial. My client's been nothing but polite to me, and I can tell you I've been nothing but polite with this pretrial officer.
All right, who's the pretrial officer?
What's his name? Joe Garcia.
All right, talk with Ms. Ferguson. We'll have them zoom in.
Thank you, Your Honor.
All right, thank you. Just have a seat. Who's here on Jared Henry? Jared Hernandez Henry? Or is it Gerard? Okay, all right, thank you.
Oh, that's the.
I know obviously.
All right, David Rodriguez, who are you here for? You're muted.
Can you hear me now, Judge?
Yes, I can hear you now. Are we ready on Derek Reyes? All right. Court is calling 2000. Could I have the files on this, please? Court is calling 2023 CR 2568 and 2023 CR 2569, State of Texas versus Derek Reyes. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
Luis Martinez on behalf of Mr. Reyes.
All right, this is a continuation of a hearing that began on March 28th. It's with regards to high BRAC readings. And I asked, and both parties agreed to have the pretrial services officer present. Mr. Rodriguez, could you unmute, please? All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
David Rodriguez.
All right, so the issues that we have is the high BRAC reading, and there's being no retest. Can you explain what is going on with regards to this? Was he at his house?
So I spoke to Mr. Reyes the day after it happened, and he stated he was at court when the retest was being asked to happen. So that's why he wasn't able to take the retest.
Okay, and what time would the retest have been requested?
It was asked to be taken at 8:40.
All right. And then it shows that there was a random alcohol test then taken on March 25th. Do you know what time that was taken?
That I'm not sure. I wasn't in office nor the one that administered the test, but it was after court.
All right, so the March 25th, 2024 random alcohol test and blow would have been taken after court?
Correct.
All right, any questions from either side?
Just briefly, Judge.
Sure.
Mr. Rodriguez, you're not the one who administered the random breath test to Mr. Reyes?
No, I was not. I was not in office this week.
Okay. So you were not in office. That was what, Monday, the 25th?
Correct. I was working remotely that day.
Who in fact spoke to Mr. Reyes that day? Or how did that happen? Because I mean, he had to deal with somebody, correct?
So let me see if it Let me see what it tells me. Let's see. So Officer Avina was the one that administered the breath test in office.
And was that at your direction?
Well, I instructed Mr. Reyes to come into the office after court for his monthly test at the office.
Okay. And so who would have decided to have the random breath test given to him?
It would have been me.
Okay.
Because it's
So-
once a month in office.
Okay. And so typically when he goes in, does he blow?
Yes. And there's never been any issues till last week.
So this one, right? Okay. So you don't know what he looked like that day?
What he looked like? No,
Yes.
I was not present.
Okay. So you don't know if there were any outward appearances that he had been drinking alcohol?
To my knowledge, no.
You don't know if there was a smell of alcohol?
No.
Yeah, because in your experience, if people are showing up and they've been drinking the night before and they're still blowing positive for you, they often will smell like they've been drinking alcohol, right?
It depends on the individual. Some individuals take mouthwash, some is the morning of instead of last night that they were drinking.
Okay. Was there any indication in the file from Officer Vina that there was any outward signs of alcohol use?
No, no indication.
Okay. I'll pass witness.
All right, any questions, State?
Just briefly, just for clarification, in the file, does it show a time at all when this would occur? Like a check-in time?
Let me check one more time, but it only shows the date, not the time. It doesn't have a specific time, it just says the date. Officer, I could check the list from last week to see if, because we work off of shifts, the 8 to 11, 11 to 2 p.m. So if Officer Avina was up there for the 11 p.m. AM shift, it would have been after 11.
Okay, and will we be able to speak with Officer Vina?
Speak up.
Possibly if he's able to hop on here, I could find out if he's working in office or remotely.
Okay, yeah, just because that's kind of, it seems like that's something that we would need.
Okay, I could
All right.
find out.
Voice is trailing off.
Sorry, Judge. Just saying that that's something that we would likely need in this case, to have Officer Avina get on.
All right, if you can see if Officer Avina is available to get on. If he's not, then the court is prepared to make a decision.
Okay.
All right, thank you. All right,
Thank
if
you.
you all just see, he's going to see if he can zoom in. Gerard Hernandez Henry. All right, they're not ready. Can you place this back and recall it later? Okay, all right, thank you. Hello? Mr. Rodriguez, did you want to say something?
Oh, yes, I was about to say something. I found a time for you. It was
All right.
11:04 a.m.
All right, so we'll bring parties back up. Where did Daniel go? Louis, could you see if Daniel went to the back? Oh, just have a seat, sir, until the parties are ready. Okay. All right. Dinah, you ready? We're back on the record in 2023 CR 2568 and 2023 CR 2569, State of Texas versus Derek Reyes. The pretrial services officer has informed the court that he was actually to find a time when the testing was done.
Okay.
All right, so Mr. Rodriguez, you're still under oath. What time was the test done?
11:04 a.m. So within a 10 minute period from that time.
All right, any other questions?
Just you.
Yes.
Mr. Rodriguez, you're assigned to Derek's case?
Correct.
Okay. And so he's using an alcohol monitor and he's on GPS. Have we had any previous violations on that since, on any of those conditions, since he got out in January 22?
No.
Thank you.
All right, any other questions?
And just to confirm, what was the random blow that was done at the probation office? What was that number?
So he has conditions of random alcohol testing as well monthly. So once a month he comes into the office to test into our breathalyzer.
Right, but my question is, what was the number that was given whenever he did blow into the breathalyzer on Monday?
Oh, it was 0.018.
All right, nothing from the state.
All right, anything else?
No, Judge.
All right, this is what the court is going to do. The court notes that this is your first alleged violation. The court notes that you're on full GPS, so the only thing he can do is come to court and go back to his home. But what I'm going to do is I'm going to order, and pretrial services, are you able to go out to his home? Is that possible?
Yes.
All right, so he's scheduled for sentencing. Just one moment. He's scheduled for sentencing on April 25th. So between now and then, not counting this week, could you do a random visit the week of April 8th and April 15th?
Yes, Judge.
All right. So if there's no objections, what I'm going to do, because I'm notating that this is your first alleged violation and you've been on this since 2022, I'm going to continue him. I'm going to order random visits by pretrial services. They're going to do it the week of April 8th and the week of April 15th. And then your sentencing is going to take place on April 25th. And the court will notate that both parties wanted Mr. Reyes to be on bond so that he can participate in depositions to help the complainants receive whatever restitution they're allowed to receive. I've done civil work before. I do know if someone is at the prison, it's hard to get depositions done. So the court will continue. There's to be random weekly field visits the week of April 8th 2024, and April 15th, 2024. And then I'm going to have you report in court so we can see what's going on, make sure everything is fine. I'm going to have you report in court on April. Nope, I better not do that. We'll just stick with what I have. And the reason why I'm saying that is because I'm not going to be the judge here for the week of April 22nd. All right. So State, is there anything else you would request? All right, anything else from either side?
No.
All right, and I'm assuming Mr. Rodriguez said that there were no issues with the breath test today?
Not to my knowledge at this time.
All right, is there anything else from either side?
No, Your Honor.
All right, thank you. No, because it's straight prison time. All right. Thank you, Mr. Rodriguez. Have a great day.
Thank you, Judge.
Jarrod Hernandez Henry. Are you all ready to proceed on this motion?
Well, Your Honor, in the state will confirm, Mr. We were here on we really just wanted to weigh in with the court to see how the court wanted to proceed.
All right, what's happening?
What's happened? He was released from custody here in Bexar County on the 17th of February. He has an MTR in Guadalupe County. He's being supervised through Guadalupe County on the probation from Bexar County. And I guess to get to the gist of it, they're considering safety in Guadalupe County, but they couldn't make that decision until this case was resolved.
All right, so what are y'all asking for on this case?
Well, there's a recommendation, Judge.
For a motion to withdraw the MTR and then to monitor the case in Guadalupe.
Which would give time for. So he would still be on probation here, Judge. And we would state to the court, everything the court told him to do since then, he has attended the meetings that the court asked him to attend. He has passed his drug test.
All right, did you do a drug test today?
And he has not done one today, Judge.
Are you ready to do a drug test today? All right, we'll do a drug test today, then we'll see where we are.
Yes, ma'am.
Probation, could you do a drug test on Mr. Hernandez Henry, please?
No, it's different. We were waiting on the feature.
He's on one.
Oh, okay. Oh, he's actually.
Hello, Mr. Garza. You're on mute.
Can you hear me?
Yes, I can hear you. Are you the pretrial service officer, Luz Briceño?
Yes, Your Honor.
All right, come forward. We're back on the record in Night Mag number 751772, State of Texas versus Luz Eduardo Briceño. All right, and you're Mr. Garza?
Correct.
All right, defense counsel says there's been some issues with the GPS device. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Julio Garza.
All right, Mr. Garza, are you the pretrial services officer for Luz Eduardo Briceño?
Yes, Your Honor.
All right, so these are the issues and this is what I'm being told. I really don't deal in hyperbole. I just want the facts. So I'm being told that Mr. Bursinio has employment. He works construction. And in the defense's motion, it says all hours of the night and required traveling depending on the jobs. All right, we're not going to do the all hours of the night. What I want to know is if he's given a set time where he can be out on employment. Are you going to be able to follow through on that, or do you need him to call in to say he's working employment?
So he would have to provide us the already set schedule for employment.
All right, so here's the deal. It's construction. Usually they don't have a set schedule. And this is from my background in dealing with construction workers and doing a little bit construction myself.
Mhm.
You don't know unless you own the business. You don't know where they're going to send you. They may need you one day in Guadalupe to lay foundation. They may need you one day in Bexar County to put up framing. They may need you one day in Travis County to do tape and float. So my question is, if he's given set hours, let's say, for example, it's Monday through Friday, 7 a.m. to 7 p.m. Can he pick up the phone, call you? If you're not there, leave a message and say, this is Luis Eduardo Briceño, SID number, give him your SID number. I am going to be at the construction site in Bexar County, hypothetically, 300 De La Rosa. And then you can check on GPS. Either he's at 300 De La Rosa or he's not. If he's not, then that's a violation. Are we able to do that?
Honestly, with that, I would have to staff it with my supervisor because I cannot really say.
All
If
right,
the
so-
situation comes to, then, and if my supervisor agrees to it, then yes.
Okay, all right, just a moment. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. State your name for the record.
Oh, Luis Eduardo Briceño.
All right. What is your work schedule?
7 to 5 or 6, it depends, 12 hours.
So you're saying 7 a.m. to 5 p.m.?
Yes, ma'am.
What days?
Monday through Friday, Saturday, overtime. And it's the one I had, it was overnight. It was gonna be night shift, so from 6 to 6 in the morning.
All right, this is what we're going to do. I'm going to allow him to work because he's already allowed to work because he's on partial. He's going to be allowed to work from Monday through Friday, 7 a.m. to 5 p.m. You should have some idea if they're going to want you to work the graveyard shift. You should know that. I know that much about construction.
Yes, Your Honor.
If he's going to work the graveyard shift, then counsel, you'll have to send notice to the court that he's working the graveyard shift in the terms of a motion.
Okay.
I will sign it. And then you pick up the phone, you're going to call your pretrial services officer, and you're going to say, again, this is Luis Briceño, SID number. I am working at construction site at 300 De La Rosa. You understand?
Yes, Your Honor.
And guess what? If nobody answers, usually a recording will come on. Leave a message. I know sometimes it gets frustrating for people. You don't want to leave a message, but guess what? If you don't leave a message, you didn't call. Do you understand?
Yes, Your Honor.
Is everybody on the same page?
Yes, Your Honor, but may I be heard briefly?
Sure.
Judge, this pretrial services officer is the only pretrial services officer who has ever called me to verify that my client was physically present for a consultation that my client had approval to be at. He gave us a hard time because we ran a few minutes late. That was my fault. I have an email here where my client asked to go do laundry and go to the HEB a day ahead of time. And the only response from this pretrial services officer was an email back that just said denied.
All right, so here's the
Restriction's
thing.
been extremely difficult. So we just asked it to
Well,
be removed from the partial.
No.
I should also tell the court, this is not a family violence case. It's going to be transferred back to CTV.
Okay, now, this is what we're doing. What we are doing is exactly what I said we're doing. he's on partial for work only. If he wants to go do his laundry, if he wants to go to HEB, then that's a motion for another day. We are just partial employment. And this is the court's ruling. Monday through Friday, 7 a.m. to 5 p.m. Understand?
Yes, Your Honor.
If it's going to be overnight, you need to let them know, and counsel, you need to file a motion. That's where we are.
How about if it's on weekends and how?
You need to file, he'll have to file a motion, and you should know about that before the weekend comes.
Yeah.
And again, you need to pick up the phone, leave a message and say, this is the location. All right, we're all adults here.
Yes, sir.
Everybody treats everybody with respect. I do understand, and I'm ordering, do I need to order everybody to treat everybody with respect? Okay, I'm ordering everybody to treat everybody with respect. Even if internally you don't respect the person, outwardly respect the person. So if you are going to be late, pick up the phone, leave a message with Mr. Garza. This is Luis Briseño. This is my SID number. I'm running late. I'm still at the work site, and GPS will show that you're still at the work site. Do you understand?
Yes, Your Honor.
I understand because I see both sides, right? I understand he's calling, verifying you that you're still at your attorney's office.
So this was 30 minutes in, Joe.
Here's the thing. This is where we are, people. We're starting off at ground zero. I've given everybody my orders. We're going to follow through with that. Nobody here's a toddler. You know, I'm learning from my niece that toddlers have demands and you need to answer those demands. But so what we're going to do, Monday through Friday, 7 a.m., 5 p.m., he's allowed to work. Even though I'm allowing you to work, on Monday, when you go to work, if you know you're going to be at 300 De La Rosa doing construction, pick up the phone, call Mr. Garza. If he's not there, because you're not the only person he's supervising, pick up the phone, call him, leave a message, state your name, your SID number, and I'm at 300 De La Rosa doing construction. You understand?
Yes, Your Honor.
If they send you to another construction site midday, your name, SID number, Mr. Garza, I've been moved to 200 De La Rosa to do construction. Are you able to do that?
Yes, Your Honor.
All right. So that's what we're going to do. And here's the thing that I want everybody to understand. Everybody has a hard day. There are some days where you meet people at their job, and guess what? They've had a hard day and they're taking it out on everybody, and their patience is non-existent. I always try to have patience, and even when I'm having a hard day, I just smile, because you know what? Once you smile, that makes the day better.
Yes, Your Honor.
Now, see, your problem has been solved. And then if you want to do the HEB and all of that, that's for another day. Let's solve the problem before me now, and we'll go from there. Now, Mr. Garza, we're off the record. Mr. Garza,
Yes, Your Honor.
is there an email that you maybe want his attorney to send an email saying where he's at as a follow-up, or is just his calling enough?
I would be preferred to be either or, both call and an email. Mr. Briseño does have my email address.
All right. So Mr. Briseño, are you able to email through your phone or no?
Yes, Your Honor.
All right. So then that's what we'll do. And guess what? Having an email, that's good for you because that's a paper trail. All right.
Mhm.
All right. So I am going to order, you're going to be allowed to work Monday through Friday from 7 a.m. to 5 p.m. And if there is a weekend issue, council, just send me the motion if he's working on the weekend.
Sure. And for the further bond conditions that the writ that we're going to file, can we get a setting today, or would you prefer for me to wait for the writ?
Oh, you have to file a writ.
Okay.
Okay. All right. Is there anything else?
I was just asking if we could calendar it so I know when to set it.
Oh, no, you can set it with Ms. Ferguson.
Okay.
All right. Is there anything else?
No. Would Mr. Garza mind sending me an email directly to my email, which he should have, but it's Joe, Joe, @hgclaw.com. And also, would he mind if I asked, does he speak any Spanish? It might help with some of our communication issues.
Yes, I do speak Spanish.
Okay.
All right, are you a Spanish speaker?
Yes, ma'am.
Oh, okay. All right. All right, if there's nothing else, then that will be that. Okay. All
Thank
right,
you very much.
Thank you, Your Honor.
Thank you, Judge.
Welcome. Thank you for zooming in.
No problem.
Who's here on Juan Arambula? Oh, you're in the center?
Yep.
All right, so where are we?
They had been asking for some discovery. We were finally able to get it from, I think, Lubbock or wherever.
Laredo.
Laredo, okay, I knew it started
Okay.
with an L. We were
Yes.
able to get that uploaded to them. We have an appointment actually in about 30 minutes for them to view the child safe interview, so we're working, Judge.
All right, Ms. Fergus, can I have a 30-day reset on Juan Arambula? This will be your last discovery setting.
Thank you, Your Honor.
Thank you,
Welcome.
Judge. We'd like to have the opportunity to review all this stuff with our
All
court.
right.
And hope you're having a great morning.
Oh, I am. Hey, at this point, anytime you're currently alive is a good morning.
May 2nd.
All right, we'll come back on May 2nd. Once you sign the reset form, you are excused.
Thank you, Your Honor.
Thank you.
Good to see you, Judge.
You too. Oh, thank you. Tyler Ashbaugh.
How are you doing this morning, Judge?
Oh, I'm doing okay. How are you doing?
Doing good.
All right, so what is happening with this case?
So, I guess kind of two things, Your Honor. I did confer with opposing counsel today. They had made an offer on the case. I don't think, I checked with your court coordinator. I don't know that today was our plea deadline day.
No,
So
it was not.
Okay, so we would certainly like a little bit of time to think about that offer and prepare counter offers for opposing counsel. We also, Your Honor, had previously filed a motion to modify bond conditions for Mr. Ashbaugh, and I believe your coordinator had emailed me last week or the week before that we could address that today with Your Honor.
Okay. All right, so first things first, Ms. Ferguson, on this case, could I have a 30-day reset for a plea deadline date? All right, so we're gonna come back on May 2nd.
Okay.
For a plea deadline date. All right, and then what's the issue before we go on the record with regards to GPS?
So the issue was previously, Your Honor, you had allowed him to take his daughter to daycare or to elementary school. The window of time that was given, he's running into issues with pretrial services. He keeps being a few minutes late. And so we're just asking to adjust that window. Instead of right now it's 6:30 to 7:30 a.m. to make it 7 to 8 a.m. I think that would allow him to do the drop off and get home in compliance
You
easier.
mean 7 a.m. to 8 a.m.?
Yes, Your Honor.
So it was at 6:30 a.m. to 7:30 a.m.
Yes, Your Honor. And I think he keeps getting back a little bit later than 7:30. And so I think that he'd be able to accomplish his same goals and be on time if we change that to 7 to 8 a.m. Or sorry, 7 to 8 a.m.
All right, State, are you going to have any objections to that?
Judge, I'm sorry. Daniel, want to just be on this case.
Well, what I can tell you is the previous modifications that were agreed to was he was allowed to transport his daughter to school from 6:30 a.m. to 7:30 a.m. Defense counsel is telling it's not enough time to accomplish that. So he would like it to be, you say from 7 a.m. to 8 a.m.?
Yes, Your Honor.
So he would like to move it from 7 a.m. to 8 a.m. No objections? All right.
All right, great.
And once I sign it, you can take a copy of it.
Thank you, Your Honor.
You're welcome. All right, they will make a copy for you in the back.
Great, thank you, Your Honor.
You're welcome.
And then I guess are we excused to sign the reset form?
Yes.
All right, thank you.
Christian Smith.
That's Your Honor.
Hello, how's it going?
Good morning, Judge. Mr. Smith's present. Judge, this is a pretrial diversion type
Okay.
situation. I've contacted Crystal Foz with the district attorney's office.
Mhm.
Left her a voicemail this morning. He has completed a class that he needed to, and then based on that, we should be able to get a dismissal. But I didn't want to have any problems with his bond this morning.
Okay. All right, Ms. Ferguson, on this case, can you just give us a 30-day reset? And then counsel, of course, if the dismissal is in, I'll sign it.
Sounds good, Judge.
All right, May 2nd. Once you sign that, your excuse. Good luck. Don't come back here anymore. You understand?
Yes, ma'am.
All right.
Very good.
All right, who's here on Amoya Lewis? All right, Miss Lewis, if you'll come forward, please. Hello.
Hi.
Hi. I'm sorry for us. We were intending to get you on the docket last week, but there were some issues. So I'm sorry for that.
Oh, that's all right.
All right, court is calling 2024 CR 2208, State of Texas versus Amoya Lewis. Could I have parties announced for the record for the state?
Jason, go ahead.
Defense?
Your Honor, good morning. Frankie Sandoval on behalf of Ms. Lewis.
And are you Miss Lewis?
Yes, ma'am.
And how do you pronounce your first name?
Amoya.
Oh, okay. Counsel, have you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find the state is in compliance with discovery. Ms. Lewis, I'm showing you what's entitled application. Okay, sure. Just give us 1 second.
Okay.
It's nice to know it's not only my software that gets glitchy.
All right, no problem. Showing you what is entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your
Does Ms. Lewis have priors?
Honor. Your Honor, not that I'm aware of.
Do you have any prior convictions?
No, ma'am.
Is this your first case?
Yes, ma'am.
All right. Could I have attorney's approach?
Thank you, Judge.
Was on probation for the trespass. And the Tony's Heights on the trespass again. And then again, the 2022.
All right. All right, no problem. You're welcome. All right, I'm going to show you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? It's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication. If for any reason your deferred adjudication were revoked, the court could fine you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Okay.
Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any, just one second. Counsel, has your client been able to provide you with any defenses to this offense?
We have discussed possible defenses. Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Judge.
Ms. Lewis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine to be probated. The state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph, did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Next, I'm showing you outside the agreement. State is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 100 hours of community service restitution, and a referral to felony drug court. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State exhibit number 1 with all the attachments.
No objection, Judge.
All right, state, you may continue to confer. Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And
Yes.
did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
In the interest of justice, we would ask so, Judge, so that the TAP evaluation can commence as soon as practical.
All right, anything you wish to say on behalf of your client?
Your Honor, Ms. Lewis presents herself here. She's been a pleasure to work with, and once we went over the facts of the case and her options, she accepted the responsibility and wishes to seek assistance so she can start putting this behind her.
All right, Ms. Lewis, do you have any support system?
Yes, ma'am.
Who would that be?
My godmother.
Okay, and where are your mom, your dad?
Currently in California.
Okay, so how did you end up in San Antonio?
My mom brought me here and just to finish high school.
Okay, and who did she bring you here to finish high school with?
Just herself.
Okay, why?
She had just exited the military and wanted to find a place to station, and she was choosing here.
All right, and when's the last time you had contact with your mom?
About sometime last month.
Okay. And have you ever had a mental health diagnosis for anything?
Yes.
What for?
Bipolar disorder.
Anything else?
And psychosis.
Okay. Do you have any children?
No.
How old are you?
27.
How far did you go in school?
High school.
Okay. You graduated?
Yeah.
Okay. And have you ever had any employment since high school?
Yeah.
Doing what?
Working at a chicken processing unit.
Okay. All right. So how often, well, when did you start using drugs?
Just recently, sometime last month.
All right. This is what the court is going to do. Court is going to sentence you to a $500 fine. That would be probated. 2 years deferred adjudication. A referral to felony drug court while in custody. Because it's Monday, they should be able to get to you this week. And even though, Michael, if you could move out of the line of sight of probation. And even though they may be full, they're about to have a graduation, so there may be some openings, okay?
Okay.
There's to be regular reporting by Zoom or in person. Regular random UAs. Field visits. 1 time per month until in treatment. TAP evaluation in custody. MIC evaluation out of custody. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. A referral to Center for Healthcare Services. If she's in felony drug court, they'll take care of that. Probation, I'm sorry, in 90 sober meetings in 90 days. Probation, is there anything, y'all need to get out of the line of sight of probation. All right, probation, is there anything else she needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. So both defense counsel and the state have told me that you've had some criminal trespass issues in the past. If you are homeless, let probation know, because they'll be able to give you some resources that can find a place for you to stay. But you cannot be picking up criminal trespasses. You understand?
Yes, ma'am.
All right. Is there anything else you need from the court to be successful?
No, ma'am.
All right. In this court, communication is key. If there's an issue, pick up the phone, call your probation officer. If you feel as though they're not addressing it, you can always come back to this court, okay?
Okay.
All right. Good luck to you.
Thank you.
And Your Honor, in that regard, would the court happen to have a card so I can give to Ms. Lewis?
Oh, probation is going to speak to her.
Okay.
Yes.
We do appreciate the courtesy extended by the court judge.
Oh, thank you so much. It's always a pleasure to see you.
Take care, Your Honor.
All right. Have a good one.
Here, Ms. Lewis. Thank you.
All right. Who's here on Oscar Olvera? And then who are you here for? Yeah, I'll take that up next. If y'all could pull that file. Court is calling 2024 CR 0289, State of Texas versus Oscar Olvera. Could I have parties announced for the record for the state?
Jason Gary.
Defense?
Jerry Valdez Jr. from Mr. Olvera.
And are you Mr. Olvera? And probation, there is an application. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Olvera, showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. Olvera, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Your Honor.
Did you understand you're charged with unlawfully carrying of a weapon with a felony conviction? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Olvera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,500 fine, no application for deferred adjudication. State recommends community supervision. This is to run concurrent with 719380. The state will take in consideration 2024 CR 3577. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 220 hours of community service restitution, no contact with Angelica Donez, Donez, and Jose Garza, or the location at Artego Street, Artego. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
No objections, Your Honor.
All right, state, you may continue to confer. Showing you do y'all have the dismissal? Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He's been in custody 171 days, Judge. While he's been in custody, he has been taking drug counseling classes. He's finished the cognitive skills course while he's been in custody, Judge. And we're asking the court to grant him probation, but we still have that County Court 11 case that he needs to take care of, hopefully today, if not this week.
Okay. All right. When's the last time you had employment?
Well, right now, I mean, I wasn't employed, but I was looking for a job. So
How long have you been without employment before being taken into custody on this date?
Like 6 months.
All right. So according to this, you were looking for your children?
Yeah.
That's either yes or no.
Yes, ma'am.
All right. And how old are your children?
12 and 11.
All right. So you hadn't been paying child support for them, obviously, because you didn't have employment, right? Before you go looking for your children, you need to have your life in order. You understand?
Yes, Your Honor.
All right, this is what the court is going to do. Court is going to sentence you to 10 years in prison, suspended and probated for 10 years. There's a $2,500 fine that is to be probated. This is run concurrent with 719-380. Take in consideration 2024 CR 3577. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. The MRT course in a parenting classes. 220 hours of community service restitution. That will be waived upon completion of the parenting classes and MRT. Proof of employment. Within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no contact with Angelica Donez and Jose Garza, or the address at Ortega Street. You're just not allowed to go on Ortega Street, Artego. Do you understand?
Your Honor, I understand. They are neighbors. He's been staying there with his father, so I told him he's gonna have to avoid that family, but he does live there.
State, you want to address the issue with the no contact?
Well, Judge, on that particular address, 326 Ortega, he went onto that property.
Okay.
We prefer at least not to enter that property or even not knock on the door or anything like that.
All right, so there's to be no contact with that property. Do you understand?
Yes, Your Honor.
There's to be no unsupervised contact with minors. There's to be field visits one time per month for 3 months. Then at probation's discretion. Probation, is there anything else he needs?
No, Judge.
Is there anything else you need from the court to be successful? I'm sorry?
No, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let probation know. If you feel as though they're not addressing that issue, you can always come back to the court. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor. Excuse, Judge.
Yes. Eric Kelly. All right, so we still have a case hasn't been indicted yet. 3 unindicted cases, and you're not on? Okay,
There's 2 other lawyers on those cases.
so who are those 2 other lawyers?
One is
Kelly Green and Anthony Zamora.
Okay. State, do you have any idea when potentially scheduled for indictment?
No, Your Honor, I mean, the biggest one, the first degree
Mhm.
from November, obviously it's a bond, so it's not
Yes,
pressing
sir.
as much, but I can reach out to the intake prosecutor and find out. The Florida Met's also, she's pretty good about following up with it.
All right, Ms. Ferguson, on Kelly, can I have a 45-day reset?
Yes, sir.
All right, we'll be back on May 16th. Once you sign the reset form, you are excused.
Yes, ma'am. Thank you, Your Honor.
All right, thank you. Thank you for dressing appropriately for court. Here you go. All right, and are we ready on Gerard Hernandez Henry?
Remember, his results were positive for cocaine.
So there we go.
Your Honor, if the court's inclined to hear from Mr. Hernandez, he would like to offer an explanation, and I think he'd be more apt to explain to the court than myself.
All right, so here's the explanations that are not going to help you. So let me just start with them. One, it's really a false positive because there's nothing. Two, I ended up touching something. That's not going to help you because you know what? When you touch items, then maybe you're not just using. So what explanation are we going for?
So even the ones that I felt previously, when I had the patches on, I never felt them back to back. And it does make sense what you're saying, but at the same time, I'm expected to sweat into the patch and comes off right away. Y'all put another one.
No. We're talking about this.
Oh yeah, I know. I'm just saying, never felt them back to back. Then it always felt for some reason. I know I have friends that do it on my softball team, and I always felt the ones that I felt were always after that. So I don't know if it's because maybe I drink water after one that does or what, but
Why are you hanging around people on a softball team who are doing drugs?
I mean, I stay away from them, but except for when we're on the field and that's it. But it's just, I know I was a little nervous to take this test because I had a feeling because I played Saturday and that's what but I believe that maybe the patch was
You
stronger.
were just doing cocaine on the softball field.
Yeah, you'd be surprised what they do. That's pretty crazy. But yeah, I mean.
Hopefully this
that's
is
only
not
my
church
explanation.
softball team.
No, ma'am. No,
Okay.
ma'am. It's not.
I didn't think it would be.
No, ma'am.
All right, so are you all still wanting to do this?
Well, Your Honor, procedurally speaking, where we are is there in Guadalupe County. We have the MTR that was moved to the 23rd of May. The reason it was moved is because there was a recommendation for safety, but because this case was still open, they couldn't do that. And so they said we'd come back here today. It was our hope that the court would consider continuing him today or withdrawing it, which is aligned with the recommendation. But of course, new things have come to light. And so at this point, we're kind of just yielding to the court in terms of what posture the court would like to take moving forward.
All right.
Given this, given the new developments. Judge.
All right. If you all want to have the motion to revoke heard, I'm inclined to have him taken into custody and he can be interviewed for felony drug court. And then if y'all will let the other county know that he's in felony drug court.
If I could just have the time
Sure.
to speak to him, Judge.
Andrew Arnett.
Morning, Judge.
Good morning. So what are we doing on this case?
Your Honor, previously, the state had given to me a body cam video that I was requesting for a while. It is on a hard drive. I have failed to review that hard drive.
Okay.
I'm asking for just a little bit more time. I don't know if we want to reset it for this week or next week, maybe Thursday, April 11th.
Okay. All right, we can bring it back on April 11th and
Is that all right?
April 11th. It's on Arnett, Andrew Arnett. And state, did you make an offer?
Sorry, I didn't confirm, maybe we make it all.
I think
Yes,
you,
Your Honor.
okay.
Yeah.
All right, so this will be your last plea deadline date. It's going to be April 11th. Okay.
That'll work, Your Honor.
All right, is there anything else?
Not in this case, no.
All right, once you sign the reset form, you are excused.
Thank you.
You're welcome. Who's here on Joshua Kilgore? Good morning. Mr. Kilgore, come down. All right, so today is for discovery and an offer.
So, Your Honor, we are making good progress. Just to kind of give the court light on what's been happening.
Okay.
Two of the individuals in this case, both the complainant and the complainant's friend, both mentioned the police report, eyewitnesses to the whole transaction. Of course, one is the complainant. Both of them have cases at large with Bear County. The former is a fugitive, so we've not been able to get a hold of her. The latter, we reached out to their defense attorney, and as of Thursday, Greg DeMary said, no problem, you can reach out to her about her involvement in this case. That was Thursday, and we intend on reaching out to that person very soon. But that is the full status update for the progress we are trying to make on reaching out to these individuals.
Have you searched the hen house, outhouse? See, he's never seen that movie.
Funnily enough, too, we have provided some materials from at least one of those people
Yes,
as well.
defense
So
have been very great about communicating with us.
we have been trying to pound this out and get somewhere on it, Your Honor.
All right, Ms. Ferguson, can you recall this for April 30th? You need to watch The Fugitive, the first.
I saw
one.
the with Harrison Ford.
Yes,
I did see it because that takes.
but
place
have you
in
seen the
Chicago.
series?
Well,
The
that's a
original.
serious question, Judge. I have not seen the series.
All right. We'll come back on April 30th.
Thank you, Your Honor.
All right, thank you.
And there is the family violence. It is the second degree. It is the one that's going to control. There are also a couple of simple possession cases that I have no doubts that we can resolve. Obviously, the second degree felony is going to control.
All right, we'll see you all back on April 30th. And if
you.
y'all have information before then, you can always come before then.
Yes, ma'am. With that, may I be?
Yes,
Thank you, Judge.
have a good one. Okay, if you all can come up with. Okay. All righty. So if y'all confer. Sure. Everyone, we're gonna be on a 5-minute recess. And if you are ready, just have the coordinator pull your file. So we're gonna be on a 5-minute break.
John was just drilling, she was telling me, no, that's on your face.
Okay, I'll call back.
So do I just keep him here?
Just here for a moment.
Okay.
Does that make sense? So far?
Mr. Ramirez, just wait for a few minutes. You're welcome. She went to the restroom.
Did this guys?
Okay. Thanks, is this name? Johnson? Yeah.
You broke your secret.
Oh, yeah. Sorry, probably need to look at it. He's got enough, she has another case that promised back is allowed.
Okay.
Yeah, he was.
Yeah.
Yeah, Thomas Beck's got, he's two different lawyers for some reason, so he'll be under this paper in a second.
Yeah, I'm under Mark. Okay, how about you message me? Okay, yes. I will. Oh, are you under Adriana? Adriana. Thank you.
We should.
All right, who is the attorney for Daniel Alexander Ramirez? All right, where's your attorney?
He got called in court this morning, so court date rescheduled for the 15th.
No, I mean, where is your attorney?
He was supposed, Joe Holtz was supposed to be here, but something happened, he got called back into court. In the 399?
Oh, he's in trial? Okay. All right, we'll recall you for April 15th. Oh, you'll get a reset form. Hernandez Blas.
Judge, he's in custody.
All right.
I want to approach on this case, Judge.
Mr. Blas, come on down.
Mr. Hernandez has a couple of, I think it's two other cases, or maybe even three, that aren't indicted yet. he had some issues. His mother is very ill in the hospital. And the last hearing, we'd asked you to allow him to be interviewed for a PR bond. He never was interviewed.
Okay.
We're making that same request.
Just 1 second. All right, you can have that heard by Judge Nahara then, since he hasn't, if you're saying the PR bond hasn't been done. Is there a reason why he hasn't been interviewed for a PR bond? It's on Blas Hernandez.
Did y'all follow the motion?
No.
Can you follow the motion?
Okay.
I'll refer to him.
All right.
All right. So we'll recall this at the end of April state. Did you tender an offer?
I haven't yet, Judge. I emailed, when we were last in court was in, at the beginning of February, I emailed the intake attorneys about these unindicted cases, asking them to review them, to either indict them or reject them. And I haven't heard anything back yet. I emailed them again this morning. I haven't made an offer yet because I wanted to see if there's a way to resolve all the cases with one offer yet.
Okay.
At the same time.
All right, Ms. Burgess, can you recall this for April 29th? All right, we'll come back on April 29th. And if you'll file that motion with Judge Nahara to be heard.
I'll do that, Judge.
All right, thank you. Richard Flores Murray.
Judge. Mr. Flory passed on March 15th. And so I have asked the family to give me a death certificate, but nobody's responded. But the DA's office said that they'll just have an investigator confirm his death.
All right, we'll recall it for April 29th and then,
Okay, Judge.
okay. All right, thank you.
Hopefully
Thank
I
you.
have an answer by then.
All right, thank you.
Thank you so much.
Can I see the file on Joseph Grosso, please? Is there a Joseph Grosso here? All right, Norma, we need his attorney here because no one knows where Mr. Grosso is. Is he on bond? Is he not on bond? All right, why is it on the docket? Oh, and no, it's reset for May 27th.
He was, he came in last week.
Okay.
So he come off the docket.
All right, so it's set for May 27th.
Oh, May 27th is a holiday. That's why I can't get to it.
All right, if you'll hand me back that. And if you'll let the attorney know.
Yes, ma'am.
All right, Gerard. All right, so where are we on this case?
Your Honor, I think it's pretty well a consensus around the treatment. The test today is going to be reported to the folks in Guadalupe. There is already a recommendation for treatment there. What we're asking is we just don't want him languishing in the jail. And we have a court date up there and then they tell us the same thing. We would ask the court to consider, after conferring with probation, the court to possibly consider putting him on a scram device and or GPS. We would ask the court to consider simply amending his bond conditions for GPS and full house arrest. But we also recognize that a bond increase, would require him to go into custody today. So that's why we would be asking for that. He has his explanations in terms of what's going on. But we would bring to the court's attention that based on the court's admonishments the last time he was here, he has completed those AA meetings. He does have proof of that. He does have a sponsor. I've had contact with his mother. I've been very, very specific, and he says that he is being helped by those meetings. I think the court could probably sense in my voice, but like I tell him all the time, I'm his attorney, I'm not his preacher, but even I'm a bit disappointed in this result today. He stands by the fact that you did not do any cocaine though this weekend, correct? And I would leave that to and that's what you would like the court to consider, that you're still saying you didn't do it.
Yes, sir.
So that's a kind of a roundabout way of saying, Judge, we're asking the court to not take him into custody today and allow him to have his court date in Guadalupe, which will probably end up where this court would be, if not.
When is Guadalupe?
It's May the 23rd, Judge.
State?
Judge, I think the issue here is that if we do something here with state ISF for safety, there's always a possibility that since Guadalupe County has their case open, that's going to delay anything we try here. I think if the court were to order safety or state ISF or extend the defendant, at that point, we could possibly get in contact with Guadalupe County to let them know what we're attempting to do, or vice versa. I think it's just one of those weird situations where we're kind of in between a rock and a hard place.
And Your Honor, if I may, to kind of piggyback on what the state is saying, I would just say that just having a good amount of experience in Bexar County and Guadalupe County, the counties kind of operate differently, not one any better than the other. But I would say that if that were going to be the outcome, and just in full candor with the court as explained to the client, that's probably going to happen. It'd probably be best to let that happen in Guadalupe County, only because he's currently a resident of Guadalupe County, and they're the ones that are doing the courtesy supervision of this probation. So I'm just saying the paperwork and everything would probably be it would just be more efficient there as opposed to
Ms.
there,
Abrams,
if that makes sense.
how are we going to address this issue?
Your Honor, as we know, the facilities for inpatient treatment, state ISF or safety, they will have him on hold until the other cases are disposed. So I believe Mr. Hernandez Henry needs some type of treatment. I do show that he did outpatient treatment before. The drug patch, he was on the drug patch for a little while. I really do believe he needs some type of treatment.
Right,
And
so you want to do outpatient treatment? You want to do the UA hotline? I mean, we could do the UA hotline. If there's another positive result, warrant's gonna be issued for your arrest because they're gonna file a motion to revoke.
Yeah, perfectly fine.
Yes, and I would like to bring him back for a status check after the Guadalupe case has been disposed, or after that's seen in court at the end of the month.
Okay, so,
And of course, we'll let the court know if Guadalupe, because, and it's in the notes, Your Honor. I've been communicating with both. You'll know if Guadalupe has made that decision to take him in, and I don't think that there would be, just like we've talked about. I don't know that I'd be making the same arguments. Matter of fact, I can tell the court I won't make the same arguments there that I'm making here. If that decision is made, then you're going to ISF or safety on the 23rd of May.
Sir.
all right. And you say it's the 23rd, right?
Yes, Your Honor.
All right. So this is gonna be recalled for May 27th. His conditions of bond are gonna be altered and amended to include the UA hotline. And then if he ends up testing positive, then a motion to revoke will be filed.
And just for the record, Your Honor, you've also been fully admonished that the court has the full range of punishment still in front of them, including prison.
So Judge, are we going to go ahead and take care of the MTR? It
No,
will be the same.
this is just gonna be amending the bond conditions unless you all want to take care of the MTR now.
The only reason why I am mentioning that is because it will be the same case once he goes to Guadalupe. If they're gonna take him in this case, the MTR would need to.
Oh, I figured you all would withdraw it then,
Okay,
because that's what you all wanted to do beforehand, withdraw it.
yes.
So
Okay,
if Guadalupe County, if that gets taken care of, then he will let us know and you all can still withdraw it. Is there anything else he needs?
I don't believe so, Your Honor.
Stop playing softball. If you're saying that's the issue.
I told him I'm done.
We're,
I do need to change the date to the 20th.
but are we withdrawing this MPR?
Yes, the 28th.
Or not today? So we'll, when do you want me to check back in?
Oh, we're gonna bring you back on May 28th.
Well, I guess what I'm saying, if this is still open and they want to take him in, would be in the same spot.
No. They'll take him in and let them know that if they're planning on taking him in to send him to inpatient treatment, this motion will be withdrawn. So that's not gonna be an issue.
Yes, Your Honor.
But sign the reset form, and I'm sorry, that's May 28th.
Good night, see you over here.
All right, Alexandria Alvarez. And Dinah, these are two, please. Court is calling 2023 CR 10964 and 2024 CR 2671. State of Texas versus Alexandria Alvarez. Could I have parties announced for the record for the state?
Hank Lucas for the state, Your Honor.
Defense?
John Robertson, I'm on the possession case, Your Honor.
Thomas Beck, I'm on the theft of the firearm case.
All right, and are you Miss Alvarez?
Yes, sir.
Counsels, have you received all the discovery in each of these cause numbers and did you review it with your client?
Yes, Your Honor.
Ms. Alvarez, in each cause number, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorneys? Did you understand it?
Yes, sir.
And each cause number, I'm showing you what's entitled true bill of indictment. Did you review those documents with your attorneys, and did you understand them?
Yes, sir.
Counsel, do you waive the reading of the indictments?
Yes, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
We are, Your Honor, in each cause.
Ms. Alvarez, in each cause number, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorneys? Did you understand them? And did you sign them in all the appropriate places?
Yes, sir.
I'm sorry, everyone, just one moment. 5 seconds.
And you send them an email, and then that's it, yes. Yeah, I know that. I think it's not, so,
All right, sorry about that.
sorry, Judge.
When you're dealing with contractors, you know, you gotta, when you're waiting for their phone call, you're like, please. I am learning a lot about contracting.
It's, you know, it's that thing, Judge, where it's like, if they're at the house and they say like, it'll cost this much, you're just like, yes, okay, can you start now?
Yeah. Well, you know, being in a hotel since August, even though I love the hotel, it's like, I'm so ready to get back home. So whenever I see, you know, the contractor's number pop up, I'm like, I'm sorry. All right, we are back on the record. And where I left off, I was showing you the court admonishments. Did you review those with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 7-1, you're charged with the offense of possession of a controlled substance, penalty group 1, 1 gram to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. In that cause number, if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And the cause number ending in 6-4, on that case, you're charged with theft of a firearm. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication in that case, if for any reason you're revoked, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
In each cases, if you have an agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Okay. Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsels, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, sir. She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir. Yes,
Ms. Alvarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
And each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. And each cause number, I'm showing you the plea bargain agreement. Did you review that with your attorneys? Did you understand?
Yes, ma'am.
And each cause number, the cases are to run concurrently. There's a $500 fine. State is recommending deferred adjudication. They are taken in consideration, County Court 2, cause number 715921 and 2023 CR 10963. And the cause number ending in 71, there's to be restitution to Live Oak PD for drug testing. And in cause number ending in 64, there's to be restitution to Julian Scales, SCALES, if any. Did you understand those to be the pleas in each of the cause numbers?
Yes, ma'am.
Defense,
Yes, Your Honor.
state?
Yes, Your Honor. The only thing I would add is, in the cause number ending in 6-4, the theft of the firearm case, she's forfeiting her right to the firearm.
All right. And that cause number, do you understand is a part of the plea bargain agreement you to forfeit the firearm?
Yes, ma'am.
Okay. In each cause, I'm showing you the waiver of appeal paragraph. Did you review that with your attorneys? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
No, Your Honor.
Next, I'm showing you outside the agreement. In each cause number, the state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation and 120 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Yes, Your Honor. I offer State's Exhibit 1 and the attachments in each cause number.
No objection. No objection.
And each cause number, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorneys? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, yes, ma'am. You said, sir.
Oh, no.
Okay.
Yeah, I'm sorry.
That's okay. Sometimes people will say that. All right, again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Right. Did you understand that today the state will be presenting evidence in the form of witnesses' statements, counsel? Witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, on behalf of Ms. Alvarez, I support to follow the agreement. I think it's important for the court to have that in September of 22. Alexandria was involved in pretty much what was a near fatal car accident. Rolled her car down an embankment. She was ejected from the vehicle.
suffered an extremely serious head injury. She had to have surgery. Was in the hospital for several months and in rehab after that. I think she's definitely a competent person. She's had some memory issues and some collateral health issues since then. I think some that may have contributed to some of her choices that's been made since then, but we'd ask the court to take that into consideration. I consulted with probation this morning. They may have a unit over there that could help her with some of those issues, maybe. We'd ask the court to follow the agreement. She wants to get her life heading in a good direction.
All right.
Judge, we asked you to follow the agreement. Maybe you can probate part of that fine. She is indigent and 120 hours is a lot of community service, but she's going to be on probation perhaps in 2 cases.
Okay. All right. And Ms. Abrams, this is probation case. All right. Do you have any children?
I have one child,
And what is your child's age?
Braxton,
Age?
6.
And where is your child now?
He is with, he's sometimes with my mom or the other grandmother or his dad.
All right. Was Child Protective Services involved?
No.
All right. When did you start with the use of the meth?
I would say I started when I was 18. I tried it. That was the first time I tried it.
Okay. And how often have you been using it?
For like the last 5 or 6 years, I was doing it daily.
All right. So when's the last time you used? And let me just tell you this, these questions I'm asking you, I used to tell my clients all the time when I had them in Child Protective Services cases or on the criminal side, and they had agreed to probation. I always tell them, hey, just lay the truth out there, because what I'm trying to do is get you the type of help you need so you can be successful. But if you don't tell me, I can't help you, right?
Yes.
And so even if you're going to be positive for meth today, you will not have violated your probation because you're not on probation. So I need you to be 100% honest with me so I can try to get you the help that you need, okay?
Yes, ma'am.
All right, so when's the last time you used?
The last time I've used was September 5th of 2023.
All right, so if you're drug tested today, is it going to be clean?
Yes, ma'am.
All right, so we're going to do a drug test and then we're going to come back and finish with sentencing, okay? Probation, could you do a drug test, please? All right, so just have a seat and then we'll take it up.
Okay, thank you.
You're welcome. Do you need any water?
Yes. No, yes, sir. I need some water.
All right, just give us a moment. Attorneys, I think there are cups in the back and, you know, we have a fountain in the back.
I can trust me very quickly.
Yes.
Zach.
Yeah.
It's a plea we're about to take. The victim and the defendant have been residing together since October. The bond conditions were changed. I just want to ask, if the victim does testify today, would you be okay with potentially entertaining no harmful or injurious contact as it has been since
Oh,
October?
I always keep an open mind.
Okay.
Yeah.
Awesome. Thank you,
That's
Judge.
me, open mind.
Absolutely. Good, thanks, Judge.
Isaiah Quarles. Who's the attorney for Isaiah Quarles? Hello. Mr. Porter,
Happy Easter, Judge.
happy Easter. Thank you for dressing appropriately for court.
You're welcome, Judge.
Yeah, that's a given for you, Mr. Porter. I'm liking the tie. You know, usually attorneys, they do this bland thing where it's just the bland color suits with the bland tie. Usually it's a navy suit and a red tie. So I always love sort of like the raw blues. So thank you.
Yeah, of course.
All right, so where are we on this case?
Your Honor, the Honorable Court appointed me about a month and a half to this case. I've reviewed the evidence with Mr. Quarles and I've spoken to the DA about some issues that I have with the evidence, and the DA is going to be reaching out to their detective to ask him what's going on.
All right, so recall for 30 days, see where we are in discovery.
That should be enough, Judge. There might be more discovery, but if we are told anything, obviously we'll tell defense, but if there's any other type of timeline that we're given. The main concern I have is that there was a piece of evidence that was selected, but I don't believe DNA was run on it. That was at least a concern that I shared with.
All right, so maybe we need to recall this within 45 days, maybe? to see if there is DNA?
I think 30 should be enough just to get that answer, and then we'll update the court and go from there.
All right, are you employed?
No, ma'am. I was actually upon being arrested, so I lost my job because I was in jail.
Okay.
So,
All right, well, when we're doing discovery hearings and your attorney will tell you that, is there an issue with you and your employment? I usually will allow people to appear by Zoom, okay?
well, as far as like checking in and stuff like that, I've been having a little bit of difficulty because I live in Shirts. I don't know if there's anything that we can do about that. And
Checking in with whom?
with pretrial services, just because I have to ask somebody to use their car, and it's been kind of a complicated
All
thing
right,
just getting over there.
Mr. Porter, if you want to set a hearing by Zoom, and we can see what's with pretrial services. When do they definitely need you to check in? Otherwise, maybe they can do it by Zoom. Nothing hurts a failure but a try.
Okay.
All right, so you want this recalled in 30 days?
Yes, sir.
All right, Ms. Perkins, can I have a 30-day reset on Mr. Quarles, please?
May 2nd.
All right, we'll be back on May 2nd.
Thank you.
All right, once you sign the reset form, you're excused.
Have a good day.
Thank you. All right, yes. Sure. Oh, we can do the drug match. Yeah, we'll do the drug match. Can you have them pass me the phone? All right, everyone, it is 11:30, so your paperwork should have been turned in.
We have 3, please, that, she's still trying to work on.
Okay. All right, no, the paperwork has to be turned in at 11:30, so it's been turned in. All right, who's here on Todd Dotson? Good morning.
We're just here on an order of expunction. And I have the order with me as well, but it's not in the file.
It's not. I don't have it.
May I approach?
Yes. All right, I'm going to sign your order, but if you can come back in the afternoon, the reason why I say that is because these were different counts. And I just want to make sure that it's in the system correctly. So I know it's going to take a little finagling.
I understand,
So,
Judge.
If you can come back this afternoon, we'll have it done.
Okay.
2 o'clock.
I'm in trial, but I might have my paralegal come by and grab it.
Sure.
Is that okay?
That's fine.
Perfect.
Yes. Where are you in trial?
Impact.
Uh-huh.
But I think they're about to dismiss it.
Oh,
but we'll
what's
see.
the impact, Judge?
More.
Okay. All right. Well, have fun. Yes.
Judge, this is on Kevin Turiel, and I think there's the procedural question is, he had 2 cause numbers and then they re-indicted it with a new cause number.
Mhm.
And what I think the state would like to do is drop the other 2 cause numbers.
Mhm.
And we'll proceed on the new one, which is the consolidated indictment with a new charge.
Okay.
Do we have it? I know he needs to be magged again.
Mhm.
Does he need to make a new bond?
That would depend on how the state is filing it. Usually, if your bondsman is okay with transferring the bond to the new case, then that can be done.
So we just gotta talk to that bondsman.
Yeah, if you talk to the bondsman and ask them if they would be willing to transfer.
We are working on it. I'm sorry for the delay. That was
No
just,
problem. I would suggest coming back in the afternoon because it's probably going to take a while for you to get the bondsman to transfer things.
okay. Thank you, Judge. May he be excused while we work on that as long as we come
Yeah,
back at
well,
1:30
We'll have you back here, let's
or
say
whenever
2.
you're to, okay.
All right.
Thank you, Judge.
You're welcome. Norma Correll, they're coming back at 2. Everyone, we're going to come back at 2 because of, I have a feeling that this is going to go back a little bit past 12 with doing the pleas. So we're going to come back at 2. But as soon as your client does her UA, we'll take care of that. All right, thank you.
Which one is yours?
I'm back at 2.
Judge, do you want everybody to just come back at 2 then, or? I mean, paperwork is in already.
All right, the paperwork that's in, I'll take that up. Everyone else, if your paperwork hasn't been completed, you're going to have to come back at 2.
Thank you.
Oh.
Diana, we're going to come back at 2 instead of 1:30.
He did. He did.
Is that?
Can I see the file on Simmons? Yeah, all right, so we'll just put him back for 2.
I don't remember.
All right, State Simmons is coming back at 2. All right, who's here on Fabian Munoz? I'm sorry, Fabian Ramirez with Zachary Munoz. That's going to be at 2 p.m. Austin Hagee, what's happening with your case?
Ready, Your Honor. Turning everything, I believe.
All right. Larry Holmes, is that going to be a plea?
Yes, Your Honor. And he's turning in the paperwork.
All right. Willie Cunningham, that's going to be back at 2. So you can leave, you'll be back at 2 p.m., okay? Terrell Goodry. We'll take that up at 2. Norma, if you'll make sure his attorney is here.
Yes, he was here, Judge. I was talking to his client.
Okay, that'll come back at 2. Timothy Johnson. That's going to be 2 p.m. Kevin Carell is going to be 2. Oscar Olvera, that will be at 2. Oh, that's done? Oh, it was. Duh. Thank you.
I'm also done, Your Honor. It's my surname.
Well done.
Get out. All right, Judge, that's my last thing.
All right, Ms. Abrams, the results of the test?
Negative.
Awesome. All right, come back forward, please. I'm so excited that it was negative.
And I've got a little more detail for the court also here.
Sure. All right, we're back on the record in 2023 CR 10964 and 2024 CR 2671. State of Texas versus Alexander Alvarez. The court has been informed that the test was negative. I'm very happy for you and proud that you're sober.
Thank you.
All right, yes.
Judge, I just wanted to follow up with that a little bit for the court's information. I noticed a tattoo on Alexandria's arm. She has a 1 day at a time tattoo. And when she snapped that date off on September 5th, that's my offense date. And I said, that's a sober day when she had it like that. So
awesome.
He was in jail until January, finally got out on bond, went straight to Haven. She's been in their inpatient program since January 17th and has got 17 more days before she graduates that program. So she's working things without being told to work things.
Awesome. That's fantastic. I'm proud of you. And yeah, 1 day at a time, 1 minute at a time.
Yeah.
All right. All right. So this is what the court is going to do in each cause number. In each cause number, the court is going to sentence you to a $500 fine. That fine will be probated in each cause. The court will sentence you to 4 years deferred adjudication in each cause number. The state was asking for 5. Let me just tell you why I'm giving you 4, because you've been doing work. And sometimes, even though these are crimes, sometimes you want to say, yeah, I did something good and somebody acknowledged it. So that's why I'm giving you 4 years deferred instead of 5, okay?
Thank you.
It's going to be 120 hours of community service restitution. Each case will run concurrent. I'm going to order parenting classes. Once you complete the parenting classes, the community service hours in each cause number will be deemed satisfied. You're to continue with inpatient treatment. at Haven for Hope. So are they having you look for employment yet or no?
No, ma'am.
All right, so proof of employment within 30 days of release from Haven for Hope, inpatient treatment.
Yes.
There should be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. And the cause number ending in 71. You are to have restitution to Live Oak PD for testing. And in the cause number ending in 64, you are to forfeit the weapon. Restitution, if any, to Julian Scales. With regards to restitution in each cause number, if you all think that the restitution is not appropriate, you can come back and we'll have a hearing on that. Field visits upon release from Haven for Hope until further notice. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and did you sign it?
Yes, ma'am.
And each cause number, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. To be successful in this court, communication is key. If you have an issue or you feel like, hey, I'm about to throw up my hands, call your probation officer. If you feel as though they're not addressing your issue, you can always come back to court, okay?
Okay.
Yes.
Sorry. Judge, we have one case being TIC'd out of county.
Yes, I've already signed the dismissal for that.
And then could we put one more thing on the record, Judge? I
Sure.
just want to ask that if you could order that the weapon be returned to the complaining witness, Julian Scales in this case.
All right, could I see the file? What cause number is that ending
It's
in?
in the one that ends in 964, Judge.
All right, could I see the file ending in 964? In that cause number, the weapon is to be returned to its rightful owner.
Okay, thank you, Judge.
So because I don't know, I don't have any information
Yes,
before me who it actually belongs to.
Yes, ma'am.
So I will say that the weapon is to be returned to its rightful owner.
Thank you, Judge.
You're welcome. All right, is there anything else?
No, yeah.
All right, good luck to you.
Thank you.
Thank you.
You're welcome. Have a great one.
You too.
Keith Hunt. Court is calling 2023 CR 10503, State of Texas versus Keith Hunt. Can I have parties announced for the record for the state?
Second time for the state.
Defense?
Brian Kimbrough from Mr. Hunt.
All right. Are you Mr. Hunt?
Yes.
Counsel, have you received all the discovery? Did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hunt, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, Judge.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Your Honor, we're waiving the habitual enhancement.
Any objection?
No objection.
Mr. Hunt, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Did you understand you're charged with assault, family choking, strangulation? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Judge.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Judge.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Judge.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Hunt, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review it with your attorney? Did you understand it?
Yes, Judge.
According to the plea, you to be sentenced in 2 years in the prison. The state recommends community supervision. They're taking in consideration County Court Cause number 7244013. They are rejecting JN number 2146922. There's an affirmative finding of family violence and no contact with Brandy Marie Hall. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent? Did you understand that to be the plea?
No, I didn't understand that. Can you tell me
Or
that?
you want to talk to him about the custodial parent?
No, you have a kid, you're,
Not with her. I have 2 kids.
so, just to be clear, he has no children with her. He does have other children. They live with you? No.
No, they live with their mother.
Okay, so he's not the custodial parent of his other children.
Well,
He
here's the thing, with an affirmative finding of family violence, all things considered equal, you're not allowed to be designated as primary custodial parent. So
Okay.
your attorney can explain to you what potentially could happen if there is a custodial issue and you head over to civil court. If you head over to the civil court, and this is just basic, right? If you head over to civil court, they're going to check, and if they see you have an affirmative finding of family violence, that's going to be held against you, more likely than not. So do you understand this to be the plea?
Yes, I understand.
Defense, is this the plea?
Yes, Your Honor.
State, is this the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Next, I'm showing you outside the agreement, the state is requesting that your community supervision be for a term of 2 years. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
I understand.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No context.
State, any evidence?
Yes, Your Honor. State offer states 1 and attachments.
No objection.
All right, and state, have you spoken with the complainant?
The complainant has made clear their lack or willingness to cooperate.
All right, thank you. You may continue to confer.
Thank you, Judge.
Mr. Hunt, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments are reviewed the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I'd like you to follow the plea bargain, Your Honor. I think you can follow all the conditions of the plea.
All right, so are you employed?
I lost my job last time I went to jail. I got incarcerated, and I've really been waiting until this gets done with because I drive trucks, so I'm kind of over the road a lot. So it kind of conflicts with my work schedule. I've been going to court every other week.
All right, this is what the court is going to do. Find you guilty, sentence you to 2 years in the prison, suspended and probated for 2 years. Take in consideration County Court Cause number 7240013, JN number 2146922. There's an affirmative finding of family violence. There's to be no contact with Brandy Marie Hall, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, the court will deem the community service hours satisfied. The BIPP course. There's to be field visits 1 time per month for 3 months. Then at probation's discretion. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I understood it.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Obviously, at some point in time, you love this person. At some point in time, and maybe still now, she probably still loves you. That's why she's not being cooperative with the state. Keep your hands to yourself. You're not supposed to be putting your hands on anybody in anger. Do you understand? If you feel as though somebody owes you money and they haven't paid it, guess what? That's what civil courts are for. Or either what I've learned in my life on the planet, if you loan money to a friend or family member or somebody, consider it a gift. Consider it a gift. If they pay you back, great. If they don't, then it's a gift. You understand?
I understand, Your Honor.
All right. See ya.
Thank you, Your Honor.
Mhm. Larry Holmes.
Ready, Your Honor.
Court is calling 2024 CR 0061, State of Texas versus Larry Holmes. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
George Schaefer for defendant Larry Holmes, Your Honor.
Are you Mr. Holmes?
Yes, I'm Larry Holmes. How you doing, Your Honor?
Oh, I'm doing great. Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Holmes, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Did you?
Yes, I did, Your Honor.
And did you sign it?
Yes, I did.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are.
Counts 1 and counts 2? I think you waived number 2.
I think he waived number 2.
Sorry about that, Judge. Yes, ma'am. We're waiving count 2.
Any objection?
No, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with unlawfully carrying a weapon with a felony conviction.
Yes, Your Honor.
That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Holmes, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review it with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's to be a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2024 CR 3061. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Could I see that file, please? Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your deferred adjudication be for a term of 6 years. There be a TAP evaluation, 120 hours of community service restitution, and no contact with Super Walmart. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count one, how do you plea?
No contest.
State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
Any objection?
No, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes,
Did
Your
you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial? I found it. A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
If we would like to, yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, this was just a bad day. Excuse me, that store, he got into an argument with someone. He was asked to leave the store. He was leaving. And at that point, the police initiated a search of his person and his property and found the gun. It's an antique gun, belongs to the family. And he's asked that one of his brothers who's licensed to carry be allowed to retrieve the gun at some point. I told him I'll help him with that.
Okay.
Yes, thank you. You know, the only reason that I came into proper possession of the weapon is my mother passed away in July of this year. All of her personal effects fell to me. Prior to that, I've never been a gun owner in my life, never wanted to be a gun owner. And, I didn't use the weapon in any kind of assault or robbery sense or anything. I only kept it with me because my house had been broken into twice. It's not an excuse, but it is an explanation for why I had the gun on me in the first place. Aside from that, I'm not a gun owner and I don't have any violent crimes in my
I'm
past.
sorry, just one moment. Yes. Chris said he would give you a call. Yes. Just one second. Oh, it's the same number that's in the text message with you. Yes. Okay, all right, thank you. He said everything was approved, so there shouldn't be an issue. All right, thank you. Bye-bye.
Getting back to your original question, yes, we'd like to proceed to sentencing.
All right, thank you. Contractors. All right, anything you wish to say on behalf of your client?
Already said it.
Okay, I know anything else
No.
based upon what he said?
No.
All right, so have you ever had any drug issues?
Oh.
Here's the thing, you need to be honest, because I've read the police report.
Yeah, I mean, yeah.
Okay. All right, this is what the court is going to do. Sentence you to a $1,500 fine probated. There's to be no contact with Super Walmart or Walmart. 6 years deferred adjudication. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. Take in consideration 2024 3061. There should be anger management classes. Felony drug court referral in custody. Be honest with felony drug court, you understand?
Yes.
Okay. TAP evaluation in custody. There should be 120 hours community service restitution, regular reporting by Zoom or in person, regular random UAs, field visits, one time per month for 3 months. Do you have any children?
No, yeah.
Okay. Probation, is there anything else? Is there anything else you need from the court to be successful? The felony drug court, that should be done by this week because it's a Monday. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. You understand?
Yes.
All right, we can go off the record. Here's the thing. I understand when people go to a place, you pay for something with cash and you want your money back. And they're telling you all they will give you is a gift card. Guess what? That's what Walmart's policy is. All they're going to give you back is a gift card. And now they've changed it. It used to be if you show them a receipt, they'll give you cash. But they don't even do that anymore. Everything is you'll get it back on a gift card. All right. Good luck to you. Adam Gonzalez. Court is calling 2023 CR 10135, State of Texas versus Adam Gonzalez. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
Michael DeLeon for Mr. Gonzalez.
Are you Mr. Gonzalez?
Yes, Your Honor.
There are no applications? Or is there an application?
There is.
I did. All right, was there an application for deferred adjudication?
No, for community supervision, Your Honor.
It may be. All right, counsel, have you received all the discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review a document entitled Application for Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
We are, Your Honor.
All right. Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with felony in possession of a firearm? Normally, the range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the state is able to prove up the enhancement allegation, then your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, off the record for a moment. Mr. Hagee, I'm sorry. I'm gonna have you come back at 2. All right. All right, we're back on the record. According to the plea bargain agreement, you agree that you've been previously convicted of 1 or more felonies. Punishment is to be assessed at 10 years in the prison. There's a $2,500 fine. State recommends community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have any such motions?
No motions, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation. Off the record for a moment. Mr. Hagee, if you have a witness, if she wants to appear by Zoom, she can appear by Zoom.
That would be great, Your Honor. I
Oh,
appreciate it.
thank you. Back on the record, $250 hours of community service restitution and no contact with the Lisa Acosta. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
To the enhancement, how do you plead? True or not true?
True, Your Honor.
State any evidence.
Your Honor, I offer State's Exhibit 1 and the attachments.
We reviewed that, Your Honor. We have no objection.
Showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor. We're asking for PSI to be waived and potentially for Mr. Gonzalez to be released pending his TAP evaluation and reporting to probation.
All right.
He does have a job he wants to get back to very badly. Additionally, Judge, when I was talking to Mr. Garahan, the prosecutor, the whole point of this probation is for him to eventually get alcohol treatment. He does want to, he's very looking forward to alcohol treatment.
All right, and the complainant in this case, Elisa Acosta, have you all had contact with her?
Check, Judge.
Do y'all need some time?
Sorry, Judge, the JD is, not cooperating.
All right, so what we're gonna do, we're gonna come back at 2 o'clock. And if y'all can get that information for me. All right,
Sounds good.
all right, we'll be back at 2.
Thank you, Judge.